Paying for residential care is so unfair. Selling your parents' home is even more outrageous. Are there lawful ways that your parents' lifetimes of savings can be kept? Answer, yes. 30 years of professional practice has equipped me with the tools I want to share with you. Everyone has heard of continuing healthcare, CHC, sometimes called continuous healthcare. That is where the NHS agrees that a family member's needs are so intense that their care should be paid for by the National Health Service and not subject to a financial assessment, otherwise known as a means test. I have a video on that topic that explains how we've repeatedly won CHC for our clients. Assuming that continuing healthcare is not an option, at Steen Law we have been successful in reducing and eliminating care fees in a number of ways. Sadly, it goes without saying, there are companies that pretend to be solicitors. They will tell you you can avoid paying care home fees. As solicitors, we can tell you this is misleading. But how much you can pay is something that we can challenge. Most people's biggest asset is their home, and it is our aim to help you to avoid losing the value from it. There are certain circumstances when the value of the family member's house can be ignored in a financial assessment, otherwise known as a means test. Where a house must be ignored, that is called a mandatory property disregard, and where it can be ignored, that's called a discretionary property disregard. Getting a local authority, social services, to agree to ignore the value of a house is a very difficult task. However, it's one we are successful in doing week in, week out. Let me share some examples from our office files. The first is where a family member has given up their own life, both their work and their home, and moved back into their parents' home and looked after one or both of their parents 24/7. Not an easy task. We have been successful in arguing that there are specific reasons, which means that it would be unfair if the house had to be taken into account and sold to pay care fees. It is one of the more complex legal arguments, however, we succeed. Another example where we have succeeded in fighting for a discretionary property disregard of our client's parent home was where our client has lived in the family home all their life and there has been no other place they've ever called home. In those circumstances, to require the family home to be sold to fund their parents' care would be unfair, and we have fought very hard and succeeded to show how inequitable that would be. Next, as an adult social care law practitioner, we're aware that the Care Act provides lots of different ways that we can defer, put off paying care fees for different lengths of time. There are lots of different disregards. There's a 6-week disregard, a 12-week disregard, a 26-week disregard, a 52-week disregard, and even it's possible to disregard, i.e. put off paying for care fees for up to 2 years in certain circumstances. The next tool in our arsenal is to look at what is the value of the family member's share of the property. This is not straightforward. Imagine if a house was worth £100,000 and it is co-owned with another family member. A local authority would like to argue that the share of the family member who is in residential care is half the open market value, i.e. £50,000. Fortunately for us, and unfortunately for the local authority social services, life is not that simple. If a family member is living in the house, there is a snappily named piece of legislation, the Trusts of Land and Appointment of Trustees Act 1996, known as TOLATA, that in certain circumstances will enable us to argue that the value of the family member's share should be discounted by anything from 30 to 100% of its value. What else is possible? The joy of being a solicitor, working with another solicitor, is pulling rabbits out of the hat. Who here has heard of the Settled Land Act 1925? Certainly not the client, who telephoned us to ask if we could obtain continuing healthcare for a family member. As is our usual practice, we got the title deeds to the property and identified a quirk that the local authority had missed. We found that this land could not be included within a means test and as such had to be ignored from the financial assessment, and we saved our client's property. It will not cost you anything for a chat. As you can see, there are options. If you would like to find out for yourself whether in your situation we can see if we can save you care fees, why not give us a call? We're here at Steenor to help.